Hi, Tanil here from studyinaustraliatv. In this episode today, episode 10, we'll discuss the regulatory framework associated with international education in Australia. International education in Australia is controlled by a number of acts of parliament and associated regulations at both the federal and the state government level. This episode outlines how these operate and which government department is in charge of what. You might ask, why does Australia regulate its international education industry? Also, how is this regulation achieved? The Australian government introduced legislation in 2000 called the Education Services for Overseas Students, or more commonly known as the ESOS Act. The ESOS Act is the primary Australian legislation regulating international education. The ESOS Act regulates the registration process and obligation of registered institutions or providers, the tuition protection service protecting students, and the enforcement and compliance of powers of government bodies. There are three main objectives. Firstly, to provide financial and tuition assurance to overseas students for courses that they have paid for, making sure that students receive the tuition that they have paid for if for whatever reason an educational institution closes. Students are provided with an alternative tuition or are given a refund. Making sure that students have access to nationally consistent arrangements to deal with student complaints or grievances. Secondly, to protect and enhance Australia's reputation for quality education and training services. Making sure that the education and training of overseas students meets national standards. Ensuring that student welfare services also meet national standards. Making sure the education providers in the industry have integrity and act ethically. Thirdly, to complement Australia's migration laws by ensuring providers collect and report information relevant to the administration of the law relating to student visas. Making sure that education institutions do not allow or encourage students to breach their student visa conditions. The ESOS Act has been represented in the form of a national code of practice for education providers to follow. The National Code is a legislative instrument and sets nationally consistent standards to support providers to deliver quality education and training to overseas students. The National Code has 11 standards that cover marketing, information and practices, recruitment of overseas students, formalisation of enrolment and written agreements, education agents, younger overseas students, overseas student support services, overseas student transfers, overseas student visa requirements, deferring, suspending or cancelling an overseas student enrolment, complaints and appeals, and additional requirements. The ESOS Act also provides a register of all educational institutions and courses that are offered to international students in Australia. This register is called the Commonwealth Register of Institutions and Courses for Overseas Students, also known as CRICOS. Each institution and course is provided with a unique identifying number. These numbers are listed on the CRICOS register, which is an online database and is publicly available. If an institution or course is not registered on CRICOS, it is not possible to apply for a student visa to study in Australia in that institution or course. The Migration Act of 1958 and associated migration regulations are the national laws and regulations that govern the issuing student, tourist, and other visas. This is the responsibility of the Department of Human Affairs, also known as the DHA, and more commonly, Immigration, which is the federal government department that controls migration and visas. So what is the basic criteria for obtaining a student visa? If a student intends to study a course that is registered on CRICOS, the student should have a relevant electronic confirmation of enrolment, also known as a COE for the course. The student must have the appropriate financial capacity to study in Australia. The student must have the appropriate academic background, including English language proficiency, to study in Australia. The student must demonstrate that they have an adequate health insurance, no debts to the Australian government, and are of good character. If the student is under 18, some further requirements apply with regard to guardianship rules. And lastly, that this student is a genuine temporary entrant and intends to return home after completing the course. Other criteria may depend on the student's country of origin and education sector they wish to study in. The Department of Home Affairs assesses the risk that a student may breach their visa conditions when they assess the student's visa application. The Simplified Student Visa Framework, also known as SSVF, came into effect on the 1st of July 2016, replacing previous streamlined visa processing and assessment level frameworks. Not all students who come to Australia to study apply for a student visa. It is possible for some individuals to come to Australia on another type of visa, including a tourist visa, which permits them to study for a maximum of 3 months, and those on working holiday visas for a maximum of 4 months. Students wishing to study in Australia for longer than this should apply for a student visa. Students studying Australian programs outside of Australia do not require a student visa. The Migration Act states that in Australia, only a registered migration agent, also referred to as an RMA, is allowed to provide immigration assistance for individuals. The Privacy Act governs what information can be shared by institutions and agents about students. This law protects the rights of individuals to have their personal details dealt with confidentially. However, some circumstances can create confusion for overseas students and their parents. In particular, for a student who is 18, information that can be given to his or her parent is limited if there's no written direction from the student. For assessing student visas, immigration risk indicators are now used to calculate the immigration risk rating of each education provider and risk level of the country of passport. If an education provider or passport level are considered low risk, then it is relatively easier for a student to obtain a visa. If, however, the education provider and the passport level are higher risks, then students must prove that they are genuine temporary entrants, also known as GTE, and have the financial capacity to pay for their study in Australia. Under the ESOS Act, an education agent must act professionally, give students accurate and current information that is from trusted sources, such as government websites and up-to-date advice from education providers. Also under the Act, an education institution must not engage in misleading or deceptive conduct in connection with the recruitment of overseas students or the provision of courses to overseas students. From time to time, an education institution may unfortunately close. This could be due to a natural disaster, such as a fire, or because of financial difficulties. If this happens, the consumer protection provisions of the ESOS Act are there to support the enrolled students. Under the ESOS Act, the provider is obligated to provide students with a refund if a course does not start when agreed or ceases to be provided after it has commenced. A refund may also be payable if a student withdraws from a course under the provider's own refund policy. As an alternative to a refund, the provider can place the student in an alternative course at no additional cost to the student if the student agrees to this. The Tuition Protection Scheme, also known as TPS, is an initiative of the Australian Government to assist international students whose education providers are unable to fully deliver their course of study. The TPS ensures that international students are able to either complete their studies in another course or with another education provider, or received a refund of their unspent tuition fees. The TPS gives students control and responsibility within the placement process by allowing students to make choice from available alternative placement options. For example, if a college closes and the provider is unable to provide the student with a refund or an alternative course, students will be offered a place in the same or a similar course with another college in the same area. There will be no extra cost to the student and they will be able to complete their studies. Now let's talk about visitor and working holiday visas. Individuals may study short education courses, usually English courses, on visitor or working holiday visas. Visitor visas allow 3 months of study. Working holiday visas allow 4 months of study. The ESOS Act does not cover students studying on these types of visa. The National Code, as we discussed, has a number of standards. Education providers must recruit international students responsibly by ensuring students are appropriately qualified for the course for which they seek enrolment, including having the necessary English language proficiency, educational qualifications, and work experience for the specific course. Students must have sufficient information to enable them to make informed decisions about studying with their chosen registered provider in Australia. In addition, registered providers must ensure that their education agents act ethically, honestly, and in the best interests of overseas students, as well as uphold the reputation of Australia's international education sector. For younger students under 18, registered providers of overseas students must meet legislative or other regulatory requirements relating to child welfare and protection. Registered providers of overseas students aged under 18 must provide the students with emergency contact information and information about how to report actual or alleged abuse. Where the registered provider has taken on responsibility for the approval of welfare arrangements for a student who is under 18 years of age, the registered provider must ensure the arrangements of the younger students are suitable, ongoing, and appropriately managed until the student turns 18 years of age. Registered providers must offer a range of student support services to assist their overseas students to adjust to study and life in Australia, and have appropriate orientation programs that help overseas students to access the information and services they require. Registered providers must formalise the enrolment of overseas students through written arrangements with their overseas students. The written agreements protect the rights and set out the responsibilities of each party, as well as the course and related education services to be provided, tuition and non-tuition fees payable, and refund policies. With regard to students who wish to change institutions, registered providers must not knowingly enrol an overseas student wishing to transfer from another registered provider's course prior to the student completing 6 months of his or her principal course, or for the school sector until after the first 6 months of the first registered school sector course. Registered providers must safeguard the integrity of Australia's migration laws by supporting overseas students to complete their course within the required duration and fulfill their visa requirements for course attendance and course progress. Registered providers must appropriately manage the enrolment of their overseas students and ensure all necessary information about enrolments has been provided to the relevant government department by maintaining updated information in the Provider Registration and International Student Management System, also known as PRISMs. For complaint and appeals, the registered providers must ensure their overseas students have the right to natural justice, protected through access to professional, timely, inexpensive, and documented complaints, handling, and appeals processes. The National Code also ensures that registered providers monitor their contracted agent behaviour to ensure agents do not engage in false or misleading conduct and avoid conflicts of interest. CRICOS is the Commonwealth Register of Institutions and Courses for Overseas Students. It is an online register of all the courses and institutions that are available to students who wish to obtain a student visa. Institutions offering education or training services to students studying in Australia on student visas are required to comply with the federal legislative requirements for registration on the CRICOS register. Some students may study a short course on another type of visa, like a tourist or working holiday visa, which permits them to study for a short period and may not be listed on CRICOS. Each institution is given a unique CRICOS provider code on registration. This code identifies the institution as a registered provider of education and training services to overseas students. Providers are required by law to include their provider code in all marketing material. For example, an institution's website usually shows the code at the bottom of each web page. This code identifies the education institution as a registered provider of education and training to overseas students. It also clarifies who is legally responsible for provider obligations under the ESOS Act. Where more than one provider is involved in the delivery of a course, only one provider is registered on CRICOS to deliver the course. The CRICOS code ensures clarity about who is responsible for any obligation under the ESOS Act and the National Code. For example, a university may enter into an approved arrangement for a college to run one of its courses on its behalf, or a number of institutions may form a partnership to offer a particular course. The registered provider will be responsible for all the obligations under the ESOS legislation. Each course also has a unique course code. Some courses may seem to be the same, but they may have different course length, course cost, or the entrance requirements may be different. In these cases, they will have different CRICOS codes. PRISMS is the Provider Registration and International Student Management System, which is a web-based database. PRISMS produces and tracks all confirmation of enrolment or COE documents that are created for international students studying in Australia on a student visa. These COEs are necessary for the issuing of student visas. CRICOS is also contained within the PRISMS database. CRICOS captures all registered courses for each provider registered to provide education to an overseas student studying in Australia on a student visa. Students on another type of visa other than a student visa do not require a COE, therefore do not require a record in PRISMS. PRISMS is used by educational institutions more than agents. However, an institution may give its agent the authority to create COEs. A COE is a confirmation of enrolment. This is a web-based document created by PRISMS that records which course or courses a student is enrolled in. If a student intends to study more than one course, more than one COE is produced. This allows the student to get a student visa for the combined length of all the courses. This is referred to as a package visa and means the student only needs to undergo one visa assessment process. Education providers also use PRISMS to report students to immigration for non-compliance relating to non-attendance in classes or unsatisfactory academic performance. For these two reasons, the student may be breaching the conditions of their student visa, so during the reporting process, PRISMS generates a formal letter that is sent to the student. This letter asks them to explain their circumstances to immigration. The letter states that the student has 28 days to make an appointment with immigration. If the student does not make an appointment, then his or her visa may be cancelled. The student may have a valid reason for the non-compliance. For example, the student may have been sick. In this case, the student must have a medical certificate to prove this. The process for applying for a student visa is quite involved. DHA require a number of criteria to be met before issuing a student visa. The student must be accepted into full-time study. The student must be a genuine temporary entrant. The student must meet health and health insurance requirements. The student must be of the appropriate age. The student must have a good character and not have any debts to the Australian government. In addition, if higher risk criteria apply, the student must provide specified evidence to meet financial requirements. The student must demonstrate appropriate English language skills. Furthermore, if the student is under age 18, they must have acceptable arrangements for their accommodation and welfare. Only students who have enrolled in full-time study can apply for a student visa, with the exception of a doctoral or PhD. The key integrity measure of the Department of Home Affairs makes in granting a student visa is whether the applicant is a genuine temporary entrant. That is, are they coming to Australia for genuine study purposes and have a realistic prospect of returning home once their studies have finished? DHA takes a balanced approach and will weigh up all the factors before making a decision. Some factors that the department considers as part of the GTE requirement include the circumstances in the applicant's home country, the applicant's potential circumstances in Australia, the applicant's immigration history, the value of the course to the applicant's future, any other matter relevant to the applicant's intention to stay temporarily. The student must make a declaration on the visa application form that includes that they have not been involved in criminal activity or they have not been previously deported. The health of overseas students studying in Australia is important and protects the Australian community from public health and safety risks, particularly active tuberculosis. To meet the health requirement, a student must be free from a disease or condition that is considered to be a threat to public health or a danger to the Australian community, or are likely to result in significant healthcare and community service costs to the Australian community, or are likely to require healthcare and community services that would limit the access of Australian citizens and permanent residents to those services already in short supply. A student may be required to undergo a health examination as part of the visa application process. An online system processes health examination results electronically, and these are forwarded to the DHA for assessment. Adequate health insurance is a mandatory visa condition. The DHA requires evidence of overseas student health cover, also known as OSHC, to demonstrate that the student is adequately insured. Usually, the education provider will include the option to pay for health insurance in the enrolment fees, and a COE will indicate that the student has OSHC arranged and paid for. Students will need to provide details of their OSHC policy in their visa application. International students have the right to choose their OSHC provider, although their education provider may make specific recommendations to applicants because they have negotiated an arrangement with a particular health insurer. A student must have OSHC for the proposed duration of their student visa. The student must not owe money to Australia or have agreed repayment plans in place. A declaration on the application form will normally satisfy this requirement. All student visa applications follow a similar process, with students providing information in a common online form to DHA, which is then assessed in accordance with established guidelines. Statistically, applications from different countries and for different providers show different rates of student fraud and visa cancellation. The Simplified Student Visa Framework, or SSVF, provides the evidentiary requirements for each student application on the basis of the risk ratings of the student's country of citizenship and the provider with which they will undertake their principal course of study. These risk ratings are updated every 6 months on the basis of rate of visa cancellation, rate of visa refusal due to fraud, rate of visa refusal not due to fraud, rate of student visa holder becoming unlawful or overstaying their time in Australia, and rate of student visa holders applying for a protection visa. Applications with regular evidentiary requirements are required to provide evidence of English proficiency and financial capacity with their applications. However, DHA retains the discretion to seek further evidence where appropriate. Applicants who provide all requested documentation with their visa applications are generally processed more quickly. Note that a student's nationality is determined by their passport nationality at the date of the application, not where the student lives or where the student applies for the student visa. The genuine temporary entry or GTE requirement remains the key measure that determines if a student is eligible for a visa grant. While evidence of finance and English is not required with all visa applications, DHA retains the right to ask for financial evidence from any student if there is specific intelligence that suggests there may be a problem with the financial capacity of the student. With respect to financial capacity, all funds that can be accepted as evidence must be clearly available to the student in order to pay for their studies and living costs. The factors that may be considered for financial capacity include the relationship of the sponsor, for example, a parent or guardian's funds are appropriate, but family friends' bank accounts are not normally acceptable. Income, assets, and employment history of a sponsor or parent. Previous visa history of the student, for example, have they had financial difficulties in the past? Students cannot rely on their ability to earn money through work in Australia as evidence of having funds. The following are sources of evidence of financial capacity. Money deposit with a financial institution or bank. Loan with a financial institution or bank. Government loan. Scholarship. If a student has dependents, they need to show access to relevant funds for the accompanying family unit, spouse, or children. DHA have designated certain English proficiency tests as acceptable and have prescribed minimum English levels. The acceptable tests are International English Language Testing System, also known as IELTS test. Test of English as a foreign language, also known as TOEFL, which can be a paper-based test or an internet-based test. Cambridge English Advanced Test, also known as CAE, or Certificate in Advanced English. Pearson Test of English Academic, also known as PTE. And Occupational English Test, also known as OET. There are some exemptions for this requirement. For instance, on an equivalency basis, if students have recently successfully completed 2 years of full-time study in an English-speaking country. In many cases, a student comes to Australia with the intention of studying more than one course. Where the student intends to package courses to combine their preliminary course of study with their main course of study, the Education Provider Immigration Risk Rating applied to the student visa application would correspond to the student's main course of study or principal course. The principal course is the course that the student intends to undertake in Australia at the highest level. For example, a student may intend to study 3 courses in this order from lowest to highest level. 1. An ELICOS program. 2. A foundation program. 3. An undergraduate degree program, which is the principal course. If that student has a package of courses that provides clear course progression to the undergraduate degree, then the risk rating that corresponds to the provider of the undergraduate program will be applied in the visa process. DHA will only recognise a package of offers if the student has a COE for all the courses, including the highest level course from the education institutions. It is not enough that the student intends to continue study at the highest level than the first course they undertake, but does not have a COE for the higher level course. A letter of offer for a course that can be conditional on the student successfully completing a previous course. In the above example, the student would have to successfully complete the foundation program before continuing to the undergraduate program. A package of courses must also increase in level across the Australian Qualifications Framework, or AQF. For example, a student cannot study a course of a lower level after one of a higher level. The duration of a student visa generally depends on the dates of study detailed in the COEs that are submitted with the application. In general, the visa granted will cover the full length of every COE that is in a sequence or package, if the evidence provided satisfies the visa requirements. Under Australian law, an individual under 18 is not yet an adult, so certain requirements apply to these students. The student must provide evidence of adequate welfare arrangements for the duration of their visa or until they turn 18 to make a valid visa application. The student must show that they have adequate welfare arrangements in one of the following ways. Live in Australia with a parent or legal guardian, live in Australia with a relative who is a student, guardian, visa holder, or holding another valid visa in Australia. The relative must be over 21 years of age with good character and be nominated by the parents or guardian. The student's education provider provides for their general welfare and accommodation by issuing a confirmation of adequate accommodation and welfare, or CAAW letter. If the student will be living with a relative but not the parent, the nominated relative must be a close relation, be aged over 21 years, have the right to remain in Australia until the visa expires or the student turns 18, and have a police clearance check. The student's parents or guardian need to prove that the nominated relative meets these criteria. If a younger student is not living with a parent or suitable relative, the education provider must sign a letter called the Confirmation of Appropriate Accommodation and Welfare, or CAAW, approving the student's general welfare and accommodation arrangements before the student visa can be issued. The provider must nominate 2 dates: when the provider has elected to begin taking responsibility for the student's welfare, and when the provider will cease to take responsibility for approving the welfare arrangements for that student. If a student's welfare arrangements are approved by the education provider, the student must not travel to Australia until the welfare arrangements are due to commence. Dates are nominated by the provider, not the student. There are age limits set for international students intending to study in the school sector. These are the age requirements that apply. A primary school student must be at least 6 years of age. Secondary students must be less than 17 years of age when commencing the academic year 9, be less than 18 years old when commencing the academic year 10, be less than 19 years old when commencing the academic year 11, must be less than 20 years old when commencing the academic year 12. A primary school student will only be granted a visa for a maximum period of 2 years. This requirement will assist to manage the welfare and immigration risks associated with younger students. If the student intends on staying after a 2-year period to continue primary school, another visa application should be submitted. There is no limitation on the maximum duration of ESOS study that can be undertaken. Genuine students will be able to undertake as much ESOS study as either a standalone course or prior to their principal course as required. The DHA does have some restrictions for particular higher risk countries though, but it is dependent on the student's GTE assessment. The students have to declare all family members on their visa application. If not, these family members won't be able to travel to Australia to visit at a later stage. The Student Guardian Visa, subclass 590, is for foreign nationals applying to stay in Australia as the guardian of an under 18 student. The student must not remain in Australia when their guardian is not in Australia unless there is an alternative welfare arrangement in place. In some special circumstances, guardian visas can be obtained to look after students who are over 18 years of age. All applicants for a student guardian visa must have sufficient funds to support themselves, the nominating student, and any secondary applicants for the duration of their intended stay in Australia. When students come to Australia, they need to understand the conditions and obligations of their student visa. If a student does not comply, their visa may be cancelled and return home. There is also a 3-year ban or exclusion period on re-entry to Australia if a visa is cancelled for breaching visa conditions. A student must attend at least 80% of their scheduled lessons, unless they are enrolled in a higher education or university course. If this does not happen, then the education provider will have documented policies and procedures stating whether they will consider compassionate and compelling circumstances. The provider must issue the student a written notification of their intention to report the student to the DHA. The letter must also inform the student that they have 20 working days within which to access the provider's complaints and appeals process. Once this timeframe has lapsed, or the appeals process has been finalised and found in favour of the provider reports the breach of the student visa condition to the DHA using PRISMs. The student will then receive a notice informing them that they must attend an immigration office within 28 days. Should they not do this, their visa may be cancelled. A student must also achieve satisfactory academic results, which is also a condition of their visa. The institution will follow exclusion procedures which the student can appeal against. If the appeal is unsuccessful, then the education provider must have documented policies and procedures for monitoring course progress and determining when a student has failed to make satisfactory course progress. The provider must issue the student a written notification of their intention to report the student to the DHA. The letter must also inform the student that they have 20 working days within which to access the provider's complaints and appeals process. Once this timeframe has lapsed, or the appeals process has been finalised and found in the favour of the provider reports the visa breach using PRISMs. Throughout their study, students must keep the education provider informed of their current address in Australia. This is because all formal notices are sent to this address. If the address changes, students must inform the education provider within 7 days. An under 18 student must have the approval of their education provider to move to another address if they are not living with a parent, guardian, or relative. If a student wants to stay at the same institution but wants to change courses with the same AQF level, they will not require a new student visa. If the new course is longer than the original course, the student should apply for a further student visa before their current visa expires. If a student wishes to undertake a shorter course than that of which the visa has been granted, then they have completed the shorter course, they must, within 28 days, either depart Australia or, if they wish to enrol in a further course of study, notify the DHA and apply for a new student visa if it is required. A student must remain enrolled in a course at the same or higher AQF level for which their visa has been granted. If the student wishes to change to a lower level program, they should apply for a new student visa. Otherwise, a student is in breach of their visa conditions and may be liable for visa cancellation or the refusal of a subsequent application. DHA place a particular focus on students who change their course very soon after arrival in Australia, large changes in level, for example, bachelor courses to Cert 3, or change to a very different course type. Where students are studying in a non-AQF course, for example, foundation programs or ESOS, and they wish to change to an AQF course, this would be acceptable. In contrast, the reverse would not be allowed, changing from an undergraduate program to a standalone ESOS program. Student breaches do not involve automatic cancellations of visas, but any breach of visa conditions does risk visa cancellation. If a student has not completed 6 months of their principal course and wants to change education providers, the ESOS National Code sets out the circumstances and process in which this may be possible. Unless special circumstances apply, they are required to have the permission of the existing education provider through a letter of release in order to transfer to another education provider. The education provider must assess a request to transfer a student, and all education providers have documented procedures on their transfer policy. Agents should make sure that they understand the education provider's transfer policy and the written agreement with the student before attempting to enroll a student with a new education provider. If an education provider does not give permission to transfer to another education provider and the student is not satisfied with the outcome of the process, they should first access the internal appeal process with their current education provider. If still not satisfied, they can appeal the education provider's decision at an external complaints body, such as the State or Territory Ombudsman or the Overseas Student Ombudsman. If the student has completed 6 months of the principal course, no permission from the current institution is required. In cases where the students have been granted a student visa based on streamlined evidentiary requirements, and they change to a provider that may have otherwise required regular evidentiary requirements, DHA may request evidence of the financial capacity and English proficiency from the student. Student visas are granted with permission for students to work in Australia. As a result, the student visa holders and their family members travelling with them do not need to apply for permission to work separately once they arrive in Australia. The student visa permits the student to work 40 hours per fortnight while their course is in session and unlimited hours while their course is not in session. A student's course is considered to be in session for the duration of the advertised semesters, including periods when exams are being held. If the studies have been completed but the confirmation of enrolment or COE is still in effect, and if a student is undertaking another course during a break from their main course and their points will be credited towards their main course. The student cannot undertake work until they have commenced their course in Australia. If a student is doing voluntary unpaid work, it is not included in the limit of 40 hours per fortnight if it is of benefit to the community, is for a non-profit organisation, would not otherwise be undertaken in return for wages by an Australian resident, and is genuinely voluntary, that is, no remuneration either in cash or kind is received. These conditions do not apply to work or practical placement that is required as part of a student's course. A dependent of a student visa holder is permitted to work a maximum of 40 hours per fortnight once the student has commenced their course. If the student's course of study is a course for the award of a master's or doctorate degree that is registered on CRICOS, a dependent may work unlimited hours. Students can enter and leave Australia as often as necessary while they have a current student visa. Students must check that their passport will not expire while they are outside of Australia. If they obtain a new passport after they have already got a student visa, they must inform the DHA of the new passport details before they travel overseas. If an under 18 student has their welfare arrangements approved by their education provider, they will not be able to travel to Australia until the date their provider has nominated as the start of their approved arrangements. Every student visa has an expiry date. In the case of a student who is under the age of 18, whose welfare arrangements are being approved by their education provider, the expiry date of the visa will be in accordance with the end of the student's approved welfare arrangements, as indicated on the student's CAAW. If a student's visa expires and they are still in Australia without having any other visas, they become unlawful and should contact DHA immediately. If they do not contact DHA within 28 days after the expiry date, they will not be eligible for the grant of most types of visas, including a further student visa in Australia. and may then be subject to a risk factor called an exclusion period. An exclusion period prevents a person from being granted certain visas, including student visas, for a period of 3 years after last departing Australia, unless certain circumstances apply. Similar to an expired visa, if a student's visa is cancelled in Australia, they will not be eligible for the grant of most types of visas, including a further student visa in Australia, and may then be subject to an exclusion period. Students may wish to remain in Australia to work after their course is finished. A student visa entitles a person to come to Australia on a temporary basis for a specified period to undertake study at an Australian educational institution. While some overseas students may decide to apply for permanent residency upon completing their studies, this is an entirely separate process. And there is no guarantee that, on the basis of having held a student visa, a person will meet the requirements to be granted permanent residency. There is, however, the opportunity for graduating students who meet particular criteria to stay in Australia and apply for the post-study work visa. In order to remain in Australia after studies, a student can obtain a temporary graduate visa. This visa has 2 streams: the graduate work stream and the post-study work stream. The graduate work stream is the same as a previous skilled graduate visa, subclass 485. The post-study work stream offers extended options for working in Australia to eligible graduates of a higher education degree. Under this stream, successful applicants are granted a visa of 2, 3, or 4 years duration, depending on the highest educational qualification they have obtained. All subclass 485 visa applicants must meet the Australian study requirement in the 6 months immediately prior to making their application, regardless of the stream that they are assessed under. The students must have attained either a single qualification requiring at least 2 academic years of study or multiple qualifications resulting in a total period of at least 2 academic years, undertaken this study in no less than 16 months, lodged their application within 6 months of completing their course when they received their results, not the graduation ceremony. To meet this requirement, the course or courses must also be on CRICOS, have been successfully completed, have resulted in an eligible qualification, have had all instructions in English, have been completed while physically in Australia, unless there is special consideration for study in 2020, have been completed while holding a visa, allowing study in Australia be counted only once towards the Australian study requirement, not be an English language proficiency course or enabling program. 2 academic years of study is defined as 92 weeks of study in a course or courses registered on CRICOS. Students may take longer to complete their course, but will only be credited within the number of weeks that CRICOS determines as a standard duration. Only study that is successfully completed counts towards the 2 academic years. Students may meet the 2-year academic study requirement when completing a course that is longer than 2 years. Credits for prior learning may reduce the amount of study undertaken. Credit granted on the basis of study undertaken in Australia in a course registered with CRICOS may contribute towards meeting the Australian study requirement, but only once. For the graduate work stream, international students with an eligible qualification who graduate with skills and qualifications that relate to an occupation on the Skilled Occupations List, or SOL, a visa in this stream is granted for 18 months. Eligible qualifications can be a degree, diploma, or trade qualification, and the qualifications must be closely related to the student's nominated skilled occupation. This means the subject matter and the skills gained from the qualifications can be applied at the level achieved in the nominated skilled occupation. For the post-study work stream, international students with an eligible qualification may be granted between 2 to 4 years of work rights. Eligible qualifications are bachelor degree, which qualifies for 2 years work rights. Bachelor with honours degree also qualifies for 2 years work rights. Masters by coursework degree also qualifies for 2 years work rights. Masters by research degree qualifies for 3 years work rights. Doctoral degree qualifies for 4 years work rights. Study resulting in a diploma level qualification or trade qualification is not eligible for the post-study workstream. All courses must have been undertaken at an Australian university or education provider accredited to offer degree level programs. It is important to note that student visas are aimed at achieving an educational outcome. General Skilled Migration, or GSM, on the other hand, is predominantly driven by the labour market needs of Australia. The criteria for grant of GSM visas can change in response to the changing economic circumstances of Australia. All applicants seeking to be granted a permanent GSM visa must meet the relevant criteria set out in the migration legislation, regardless of whether or not they have been previously in Australia. It is important for student visa holders to note that any changes to the criteria for the grant of a GSM visa would not affect the student visa conditions. Now let's look at the privacy legislation in Australia. The Privacy Act was passed by Federal Parliament in 1988. This legislation relates to all people in Australia and applies to people working with international students. There are 4 general issues you need to be aware of. Collection of information is quite specific. An agent or institution must only collect information that is necessary for its normal function. It cannot collect information about a student that is unrelated to its function. The student must know if information is collected. If practical, information can be collected from the student and not from other sources. The use of information is also quite specific. An institution must only use the information for the purpose that it was collected for unless the student agrees to it being used for other purposes. Security of information is very important. An institution must protect the student's information from loss or misuse. Access to information is allowable in that the student can have access to their own information on request. The National Code states that in formalising the enrolment of a student, a registered provider must enter into a written agreement that sets out the circumstances in which personal information about the student may be shared between the registered provider and the Australian government and designated authorities, and if relevant, tuition protection schemes. This information includes personal and contact details, course enrolment details and changes, and the circumstances of any suspected breach by the student of a student visa condition. This means that an institution must inform the student what information they will collect and who they will pass it on to. If international students do not get the services they paid for, they have a right to complain. When they have an adverse judgment made against them, such as failing a subject or not meeting the attendance requirement, they have the right to appeal the decision. In the first instance, these matters will be dealt with internally, and the education provider will have a complaints and appeals process that should be followed. The Overseas Students Ombudsman, or OSO, deals with student complaints made against any private educational institution. Government institutions use a state ombudsman or range of tribunals depending on the nature of the complaint or appeal to serve the same purpose. The OSO do not investigate complaints where a student has taken more than 12 months to complain. When a complaint is received, an assessment is first made about whether or not it is an issue the OSO can investigate. In some cases, the Ombudsman may decide not to investigate a complaint. The Ombudsman may request relevant documents or information, such as student records, from the provider. At the end of an investigation, the Ombudsman may conclude that the provider has not acted unreasonably and will advise the student and the provider of this decision. In other cases, the Ombudsman may conclude that the provider failed to take appropriate action. Where that happens, the OSO may recommend that a provider remedy the problem. So that's the end of this episode on the regulatory framework covering international education in Australia. I'm sure you'll agree it's lots of important information. Let us know if you have any questions. We'd love to hear from you. Bye for now.